Welcome to the Real Estate Espresso Podcast, your morning shot of what's new in the world of real estate investing. I'm your host, Victor Minash. On today's show, we're talking about conservation easements. We tend to think of the income tax code as a mechanism for extracting revenue from the population and from businesses. And to be fair, that's true. But there are thousands upon thousands of pages in the tax code. You can describe how much a business or an individual needs to pay in income tax in a very small number of pages. The remainder of those thousands of pages is primarily a series of incentives, and conservation easements are one of those incentives. Under standard conservation easements, landowners give up development rights for their acreage to a land trust. In return, they receive a charitable deduction equal to the property's value at its highest and best use, and the public benefits from the preservation of the land, which in some cases might be made available as a park. In order to be eligible for conservation, the land must have actual conservation value. If the land was previously developed, it's unlikely you would successfully argue that the property has conservation value. Conservation easements are more robust than zoning when it comes to protecting land. Zoning can be changed, and conservation easements are perpetual. But there have been arguably abuses of this provision that went far beyond the original intent of the legislation. In particular, the so-called syndicated conservation easements have been deals where promoters would buy a piece of land for a low price and then go get an appraisal for the value of the land as development land, regardless whether there was any realistic development potential for that land. With that appraisal in hand, the land would be donated to a land trust and the promoter would claim a tax deduction for the appraised value of the property. In 2017, the Internal Revenue Service put out a notice that these types of transactions had been classified by the IRS as listed transactions. That's code. It means these are reportable as abusive tax shelter transactions. In those transactions, promoters purport to give investors in a partnership or a pass-through entity the ability to claim a charitable contribution deduction that far exceeds the invested amounts. Now, the Sixth Circuit Court of Appeals and the U.S. Tax Court in recent litigation held that listed transactions have to be identified in the regulations and not through the supplementary guidance such as the notice that the IRS put out. So the government responded in kind, and the Biden administration buried the new legislation regarding conservation easements in a bill that passed at the end of 2022. The new measure will limit taxpayers' deduction to 2.5 times their investment. That will effectively eliminate the profits that drive syndicated deals while allowing traditional conservation easements to continue. What this really means is if the charitable deduction exceeds 2.5 times the original investment, the transaction would be treated by the IRS as a listed transaction. That doesn't mean the deduction would automatically be invalid, but you could expect a tremendous amount of scrutiny and potentially aggressive treatment by the IRS. Specifically, the IRS is clamping down on investment in land for the sole purpose of getting a tax deduction. The notion that an investment generates a tax value greater than the original investment is seen as an abuse of the law. The IRS is going after promoters who have been promising returns where the primary source of the return is a huge tax deduction. An investor receives promotional materials, whether written or oral, that offers investors in a pass-through entity the possibility of a charitable contribution deduction that exceeds an amount 2.5 times the original investor's investment. In that case, you can expect to be under IRS scrutiny. The new legislation has caused some people to wonder whether conservation easements are dead. I believe the proper use of conservation easements is actually alive and well. There's obviously more to the new regulations than I've got time to outline in a brief podcast, but my reading of the regulations suggests that the IRS is looking to cap the charitable donation deduction to a maximum of 2.5 times the investment. And why is that 2.5 number important? Well, the cash value of the deduction, even at the top marginal tax rate, would be less than the original investment amount. And the thinking is it removes the incentive to make an investment for the sole purpose of generating a tax benefit in excess of the investment amount. Now, in our case, we own a large development project on the outskirts of Colorado Springs that's over 1,700 acres. And to be clear, we've not made any final decision on whether to donate a portion of our land to conservation. Our master plan for the project, as submitted to the city, has a significant amount of open space. We also believe that some of the land that borders the waterways on the property do have true conservation value. When the property gets developed, and if a small portion, maybe 5 or 10% gets donated to conservation, as I read it, This would be considered a perfectly legitimate use of the conservation easement regulation. It would indeed comply with both the letter and the spirit of the original and the revised legislation, and the tax deduction would not exceed the threshold set by the IRS. The proposed regulations make it clear that the IRS is going to continue to aggressively challenge conservation easement transactions in the years ahead. But they do remain in effect, and they give you an opportunity to do well and do good at the same time. As you think about that, have an awesome rest of your day. Go make some great things happen. We'll talk to you again tomorrow.